When drafting the Oregon Realtors Forms in the inspections section, there's a special clause that allows various inspections that are invasive inspections to be done without requiring seller pre-permission. Now, the reason for that is a scenario, a situation where the buyer has a whole house inspection of the done to the property. The seller approves. They have a little sheet and they say, yes, you can do a whole house inspection, but nothing else. No pest inspections, no dry rot, no mold, etc. The buyer does the whole house inspection, and the inspector comes back and says, I saw signs. You need to do a pest inspection because I've seen some things, and it might imply that there could be a problem. In those cases, the problem that arises is when the seller says, nope, we already agreed. All you were doing was a whole house inspection. You don't get to do a pest inspection. We found that process created a liability for both the seller's side and the buyer's side because essentially the parties were at an impasse over something generally unreasonable. What we've done instead in our form is said if the buyer during the inspection period, during the due diligence period, wants to do a mold inspection, a dry rot inspection, a pest inspection, sewer scope, oil tank locate, or a radon test, they can. They don't have to ask for extra permission to do these tests. What that means is when the buyer's first inspection triggers a second inspection of one of those 6 types, the buyer doesn't have to go back and ask for extra permission with the chance of spawning a lawsuit. In summary, the Oregon Realtors Forms allow the buyer to do various 6 types of inspections without having to ask for extra permission. Those invasive inspections are simply under Oregon Realtors Forms not considered invasive and therefore don't require additional permission.